Let's talk about Hot Girls Read. As a trademark attorney who's also a book girly, it's important to know that nobody owns the words Hot Girls Read outright. When you file for a trademark application, there's different types of refusals that you can get. One of those being failure to function as a trademark. So when the USPTO reviews these applications, one question they ask is this a commonly used phrase or saying, or does it function more like a brand? Examples of phrases that function as a brand are just do it, or I'm loving it, got milk. All of those are commonly used phrases, but they're associated with a particular good or a service. And those phrases weren't commonly used in connection with those goods and services before it was trademarked. So now the question becomes with Hot Girls Read, was that phrase commonly used when it came to apparel, stickers, bookmark? Because if the answer is yes, then this is going to be a lot harder to enforce. So the examiner who is essentially approving this application has to ask, would most people see Hot Girls Read as a brand, or would they see it more as a reading slogan and not as a source identifier? Hot Girls Read was a common expression before the application was filed. And I do think that consumers perceive this more as a social expression and not as a source identifier for a brand. So I do think that this one is going to be a difficult one to enforce. Obviously, I can't give legal advice, but I am curious to know what your thoughts are down in the comments.